Our last speaker today is Mr. Y.Nessibov. He is the advocate and member of the Bar Association of the Republic of Azerbaiján. He holds the LLM degree from UK and a PhD degree. He's a partner in the law firm Y.Nessibov and Partners. He specializes in commercial law, contract law, administrative law, and banking law, in addition to working in the field of oil and gas. I request Mr. Yunis to give it.
Good afternoon, everyone. I would like to thank you for your invitation on behalf of myself and on behalf of my colleagues and our delegate from Azerbaijan. Previous speakers mentioned about the domestic arbitration and the international arbitration, and I will address mainly the regulation and practice of commercial dispute resolution and arbitration in particular in Azerbaijan. While there is a significant uniformity in international arbitration legislation around the world, there are some differences on how the national arbitration law and the courts implement them and apply the New York Convention. I believe the prevailing approach in Azerbaijan is to choose litigation over the alternative dispute resolution. As a matter of practice, commercial practice, do not refer disputes to domestic arbitration in their contracts. In Azerbaijan, the practice of alternative dispute resolution is relatively new, and it's in the process of development. The Bar Association of the Azerbaijan Republic is taking the leading role in this process, and it regularly organizes the conferences, roundtables, seminars, and the member of the bars, the advocates, are taking active role in various international organizations, giving lectures in universities about the commercial dispute resolution and arbitration in particular. Within the Bar Association, we also have a business law committee that deals with business and commercial law. It greatly contributes for the development of this area. Azerbaijani law recognizes the right of parties to refer dispute to arbitration in another country or to a tribunal in Azerbaijan, which will apply on the foreign law. The national procedural law of Azerbaijan Republic on international arbitration includes the Civil Procedural Code and the Law on International Arbitration dated 1999. In early 2000, Azerbaijan Republic ratified and acceded to the 1958 New York Convention on the recognition and enforcement of foreign arbitral awards. And Azerbaijan also is a party to the Washington Convention on the settlement of investment disputes between states. However, even prior to that, the Republic of Azerbaijan adopted many conventions and became a member of different international organizations. For example, International Center for Settlement of Investment Disputes of 1965 and the European Convention on International Commercial Arbitration of 1961. The law on international arbitration in Azerbaijan has been enacted on basis of conceptual model law on international commercial arbitration, and I'm sure this is the same case in many countries. The main object of this law is to encourage settlement of disputes amicably via the arbitration. When talking about the particularities of international arbitration, there is almost always an issue with the country's own legislation, and in Azerbaijan it is certainly worth noting that there is an important lexicological inaccuracy within the laws was enacted because the arbitration was new at that area, and of course this may cause confusion. In my opinion, the legislation in all countries, including Azerbaijan, should be unified and consistent with each other in order to get the desired outcome, especially in practice of recognition and enforcement proceedings. Nowadays, it is difficult to imagine the resolution of disputes in international and domestic commercial relations without the arbitration and mediation process. In 2019, the law on mediation was adopted in Azerbaijan, and this law regulates the public relations in the sphere of establishment of mediation as one of the alternative dispute resolution methods. The adoption of the law on mediation is an integral part of the ongoing judicial and legal reforms in Azerbaijan. According to the law, mediation is a process defined by the law on mediation, which regulates settlement of disputes arising between the parties through mutual consent and will be applied to the civil and economic disputes. Currently, it is compulsory for 3 areas in Azerbaijan, and those areas are labor, family-related, and commercial disputes. In a way, it's good that it's a compulsory, in my opinion, because there are real cases that can be solved in mediation without taking the traditional route of litigation. It can save time, money for parties, and minimize the caseload of the courts. In my opinion, also the mediation plays an important role, especially in commercial disputes. As I mentioned, there are ongoing judicial and legal reforms in Azerbaijan. We are taking part in many projects related to dispute resolution, and members of the Azerbaijan Bar Association are active members of the ICC committees, the London Court of International Arbitration, as well as the ICCA, the International Commercial Court of Arbitration, and they also act as international arbitrators in the relevant field. Students are also, in the universities, are taking part in the international moot competitions, and they are all making contributions for development of this area. There are also many projects that were carried out by various international organizations. For instance, in 2021, the European Commission, together with the Minister of Justice of Azerbaijan, had a project called the Support Further Development of Alternative Dispute Resolution Services and Specialized Courts in Azerbaijan. During this time, 10 to 15 members of the Bar Association, the advocates, were elected and enrolled on the initial course on arbitration. This all shows that as a country, we are very interested in developing the commercial dispute resolution and ADR. The end of October 2002, the New York Convention roadshow was held in Baku, Azerbaijan, and during the event, the new Azerbaijan translation of the ICCA Judge's Guide to the Interpretation of the 1958 New York Convention was officially presented. The event drew nearly 100 in-person attendees, including the judges, attorneys, state officials, and professors. The event was co-hosted by the Azerbaijan Bar Association, the UN High Commissioner for Human Rights, the Baku office, and the Small and Medium Business Development Agency of the Republic of Azerbaijan. Currently, there is a new law on arbitration is in the process of drafting, and we hope it will be accepted in the near future. Also, there are new law on investment, which is very good for the investors. This will protect the rights of investors and give them the peace of mind. At the same time, I'd like to mention that many books during this time were published in relation to commercial dispute resolution and arbitration in particular. This all helps to educate the young lawyers and students on this subject. And again, the Bar Association is playing an important role in all these projects, and recently, in October of last year, as I mentioned, the New York Convention of Roadshow was held in Baku. The new arbitration, in addition to all this, what I said, the new arbitration center in Alat Economic Zone. Basically, this is the new authority, the new institution for us as well, and it will basically deal with the disputes between the residents of the economic zone. It all shows that there is big developments in this field. And Azerbaijan, being an oil exporter country, Azerbaijan also has joined to the Energy Treaty Charter, and the treaty provides a multilateral framework for energy cooperation that's unique under the international law. And the main purpose of the Energy Treaty Charter is to strengthen legal norms in the energy sector by establishing uniform rules to achieve the compliance with these rules by all participating governments, while minimizing the risk associated with investment and trade in the energy sector. So, as you can see, there are many ongoing projects and legal reforms in Azerbaijan. However, there are still challenges in this area which needs to be overcome, especially in the area of enforcement. And in conclusion, as a country, as I said again, I will not repeat myself, we are very interested to overcome those challenges and also interested in further development of the commercial dispute resolution. I believe the outcome of this convention will be very useful, and we as advocates, lawyers, and practitioners, even students, can benefit from this as a whole. Thank you very much.
Now I request the chair of this session, Mr. S. Nagan, to give his presentation.